Flip green, give me a 1, 2, 3.
1, 2, 3.
Perfect.
According to the clock, it's 12 noon, so I'll say good afternoon, everyone. I'm Robert W. Matanke, president of the Decalogue Foundation and a past president of the Decalogue Society of Lawyers. It's my pleasure today to introduce our guest speaker, David H. Levitt. The topic today is defining hate speech. When does speech cross the line? Mr. Levitt has practiced law here at Hinshaw Culbertson since graduating in 1979 from Loyola Law School. Started obviously like this firm does in defense work. And then a few years later, he did something gutsy and went for an LLM at John Marshall Law School in intellectual property. In 2000, when he got the degree, he transferred his practice into intellectual property and co-founded that section at Hinshaw, the law firm here. He's co-chair of the advisory board of the DePaul Law School Center for Jewish Law and Judaic Studies and provides unique programming not found elsewhere, including its April 2022 symposium, Defining Anti-Semitism and Why It Matters, an in-depth exploration of the competing definitions, which Mr. Levitt co-chaired, and he was one of the presenters at that program. Mr. Levitt is also presented at Stand With Us International Conference on International Law regarding Israel's legal borders. And among other things, he's a past president of his congregation, B'nai Tikva in Deerfield. Mr. Levitt is an active blogger on the English language centrist Israeli newspaper Times of Israel on such topics as international laws applied to Israel and anti-Semitism, among others. On February 12th of last year, 2023, he published an article entitled Free Speech versus Hate Speech, Finding the Right Test Case. That article was updated in the Decalogue tablets, and a result of his research in this area of First Amendment, David has presented a CLE seminar for us, for the Decalogue Society of Lawyers, on December 20th of last year, entitled Hate Speech and the First Amendment. That seminar was very well received. I was there, it was wonderful, and that's why we got today's sequel, because you're being called back for an encore. So accordingly, to all of you who do not already know him, it is my distinct privilege to introduce David H. Levitt, as he will present Defining Hate Speech, When Does Speech Cross the Line, and to also thank you and your firm for hosting us all for lunch.
Thank you. I don't need that. I have this over. I believe we need to get this one out of the way. Thank you. Technology. Hello, everyone. All right, we are live. So thank you, Bob, for that. And so these next two slides will be redundant. That's who I am. And that's a few of the things that I've written. So if you want to see, there's 40 or so articles on there dealing with all sorts of topics involving Israel. You can see, and anti-Semitism and civility. And by the way, there's 3 on gun control and the legal issues of gun control and whether the Second Amendment does or does not prohibit gun control. Now we're going to be talking about whether the First Amendment does or does not protect hate speech. Actually, we're not going to be talking about that because we talked about that previously in the December 20th program and in this paper. This is a subsequent paper in March of 2024 that Bob mentioned on the First Amendment and hate speech and whether it is or is not protected by it. And what I did was I concluded, I went through it and I left out a topic, which is what today's topic is. The topic then was, assuming we all agree it is hate speech, is it or is it not protected? And in my conclusion was that it is not. And then and I went through all the case law that talks about that. and that in fact, the courts have never actually said that hate speech is protected. And there are legitimate arguments that it is not protected. And what we need to do is find a test case with good facts to bring it up. That was the topic of that paper and of what I talked about in December for the Decalogue Society. So now we're going to cover the topic that we left out, which is, okay, let's assume that I'm right. Now, I may not be, because there hasn't been cases either way on it yet. Let's assume I'm right that hate speech is not protected. What's hate speech? That's what we're going to cover today. But first, let's talk about some things that are precursors to this, that precede the issue, which is doctrines that have been around for a long time, which involve speech and specifically allow restriction of speech. And the leading case on this is from 2003, Virginia versus Black. And in that case, the court was considering cross burnings, and the statute prohibited cross burnings with intent to intimidate. And that's important because in criminal cases, intent is required. And the Supreme Court upheld the statute, except one thing. The statute presumed intent from the fact of cross burning. And the Supreme Court said, no, that's not sufficient. And that's a theme throughout all of the jurisprudence on true threats and on criminal conduct involving speech, which is the intent requirement. But the court did not hold that you could not criminalize what would otherwise be considered as symbolic speech, such as burning a flag or burning a cross. Those would be considered what the court has upheld as speech on occasion. Symbolic speech, but if it's done with an intent to intimidate and you prove the correct intent elements, the court held that it could be criminalized. That means there were consequences. So therefore, the court ruled that true threats are not protected speech. And this is the court's definition of true threats. And it's important to keep in mind that the speaker need not actually intend to carry out the threat. It's the threat itself that can be prohibited under the true threats doctrine. And however, there's a limitation even under that doctrine, which because it has to deal with violence. You have to have a threat of violence. If you have a threat of other things, at least under the current jurisprudence, it hasn't been tested. Nobody's tried to bring another case. So after all, the true threats doctrine came up in 2003, some 34 years after the imminence test in the Brandon versus Ohio case. And so the court in Black, and Virginia versus Black, created a new restriction, a new test for whether speech can have consequences or not that didn't exist 34 years earlier and didn't exist for the remaining 34 years. And so we may be able to create a new extension of that because the court was dealing with intent of placing the victim in fear of bodily harm or death, that is violence, and not other things. So what I'm going to tell you is the things I'm talking about today are not limited to anti-Semitism. I come at it from a perspective of fighting anti-Semitism, but it could be racism, it could be Islamophobia, it could be hate speech against the LGBTQ community, it could be anti-Asian, it could be any community. It could be minorities saying things against majority that otherwise qualify as hate speech. So while I'm bringing to you examples, and I have talked, Hinshaw has a very robust and DEI department, which includes the Jewish community. Thankfully, and has been very supportive of it, and I always thank them for it, and they deserve that thanks. Okay, we're one of the few firms that has a Jewish cultural heritage affinity group, and that's because of the support that we get here at Hinshaw. So, but while I'm bringing these examples, I am telling you that these are not limited to those, but it obviously is what drove people to want to see this program as well, because it is the issue that's pending. So here's true threats examples. These are, you can look at it, it's on video. These are what people are saying many of the people are saying at these protests. And in fact, in my view, at least as reported, it's the majority of what's being said. Never forget October 7th, we're going to do it again and again. It will be every day for you. This is in the United States being said. Al-Qassam, you make us proud, take another soldier out. Burn Tel Aviv to the ground. We support your rockets too, Hamas. I've been to programs, I've listened to programs from other communities. These don't mention anything about Israeli policy, about the current Israeli government, which, by the way, I oppose. It doesn't say, but these statements, these chants, we can talk about River to the Sea and we can talk about other things, but these chants are unquestionably true threats, and they don't have anything to do with criticizing any Israeli government actions or policy. And this one, you may have seen video of this one, but there are some Jewish ralliers, protesters, and this woman was standing in front and saying, here's the next target. That is absolutely a threat of violence against those people, even though this person had no intent to actually do a rocket of her own. That's a true threat under the current jurisprudence of the US Supreme Court. And so that was before we get to the defining hate speech, the first question was, well, there's already some speech restricted, and what we're seeing on campuses and elsewhere is already prohibited by and not protected under the First Amendment, under doctrines that have been around for a long time. And here's another set of doctrines that also restrict speech and has been around for a long time. 1964, it involves obscenity, and it is the famous concurrence by Justice Stewart, in which he said, I know it when I see it. We've all heard about that one. Everybody who's a lawyer certainly heard about it when they were in law school. It's one of the most famous pronouncements involving obscenity and about speech. It was a concurrence. It wasn't even the majority opinion. In fact, there was no majority opinion in that case. And the court actually ruled in its plurality opinions, plurality opinions, that in fact, the film at issue was not obscene, but the way they did it was not some test that was created that they applied. They all watched the film themselves, reached their own conclusions. And that's going to be an important theme, as we see throughout. The court has made it absolutely clear, this is 1957, that that obscenity is not protected speech, never was. It's not within the area of constitutionally protected speech. It's not an exception. It just was never protected speech in the first place. And this is an important phrase because we're going to see that it applies, in my view, equally to hate speech, which is that convictions, and by the way, we're talking about convictions, not civil law here, criminal, can be upheld without proof that the obscene material actually created a clear and present danger. That's the Brandenburg test, and that's also the test on fighting words, all right? Don't have to have a clear and present danger of antisocial conduct, or that it will probably induce its recipients to such conduct. So in the obscenity area, an area of restricting speech, considering the First Amendment, the court has not required that speech that the people prosecuting criminally or civilly have that kind of proof. In fact, in a couple of years later, 16 years later, in Paris adult theaters, the court created a balancing test for speech. Now, just to give you an example, when the Supreme Court went in the most recent gun control case and the Second Amendment considered the test to be applied, they specifically rejected a balancing test. I have problems with that. That's not the topic of today's discussion. But the point is that as to speech, at least in the obscenity area, in my view, extends beyond the obscenity area, a balancing test of legitimate state interests applies. In my prior presentation, I suggested that we use a test, the test for commercial speech under the Central Hudson case, which it's a 4-part test, and I think that should be applied. But the point is that as to speech, both as to commercial speech and here as to obscenity, the Supreme Court has specifically adopted a balancing test of legitimate state interests against other factors that may be applied. And here's a definition from Miller versus California. I'm sorry, I made it so small that I can't see it from where I am. But the court pointed out that it has been categorically settled that obscene material is unprotected. The basic, and then it set out the three-part test that whether the average person using contemporary community standards, I want to point out, I want to stop there because there's two questions of fact there every time, right? You don't know ahead of time whether or not those standards will be met. You have to have a factual determination on a case-by-case basis. What will the average person do? And what will be the community standard? So even in part A of the test, there's two questions of fact that have to be determined on a case-by-case basis. Whether it depicts it in a patently offensive way that is specifically defined by the applicable state law. Now, what they're requiring is that the state be specific about what they want to criminalize or not, if it's a criminal case. And since it's Miller versus California, it is a criminal case. But okay, how specific is it? We're going to be litigating that issue on a case-by-case basis as to whether the statute is specifically defined enough and whether or not that definition that meets the facts of the given case. And then the third part of the test is that it lacks serious literary, artistic, et cetera, value, which of course is an issue in hate speech as well, because hate speech also lacks serious literary, artistic, political, or scientific value. So the obscenity test, as applied here, would apply equally to hate speech. And for those who contend, and there are many, I've read dozens of academic articles going in both directions on this topic, who contend that and that it will chill speech, that people won't know in advance. And by the way, in the last term or the term before, then the Counterman case, the Supreme Court in 2023 specifically made reference to the concern about chilling speech, that people won't know which side of the line they are on before they say it. As to obscenity, the same court, not the same court, this is 1973, not the same set of judges, specifically said that those three prerequisites provide fair notice that if you do these things, or you say these things, or you engage in this kind of speech, that you may be prosecuted. And the court said that that was sufficient under the First Amendment. And for those who take the absolutist approach, those who say, doesn't matter, the ACLU has always taken that approach, according to many of the articles I've read and what I've read from them as well, although one could argue that they've modified their own positions on that over time, at least in certain substantive kinds of claims. The court specifically said that we will not take an absolutist approach, that we reject an absolute anything goes approach. And one last thing about this 1973 Supreme Court decision, the court said that the interests of free speech are adequately protected because there is ultimately independent appellate review. There's always independent appellate review, but the court felt the need to make that specific statement in the opinion, just as it did, by the way, as I pointed out in my last presentation in December, in Snyder versus Phelps. Every case is limited by the facts before it. Every case, you don't have to say it. And yet the Supreme Court in Snyder versus Phelps, which was the Westboro Baptist Church picketing the funeral case, specifically said at the end of the opinion, this case is limited to those facts. The court was self-restricting its own opinion, because even though that's true in every appellate decision and Supreme Court decision ever rendered, the fact that the court felt the need to say that is itself telling. So what I'm suggesting here is that we need a further place to regulate speech. Cases haven't come out under these fact patterns yet, at least they haven't gone up. And I haven't seen one even at the trial court level that would apply when it isn't enough to be a true threat. That is, it's not a threat of violence, although some of these, as we've seen, are and do apply. And hate speech has a problem. It creates a discriminatory and chilling environment for those who are the subject of the speech. There is very little debate in the academic literature that hate speech causes harm. The question is whether that harm is one we just have to accept, or whether it was something that the courts have the right to do something about. And it normalizes speech. We see it all the time. And it leads to radicalization. I've just used two examples here. There are many. The Tomna versus Twitter case from a couple terms ago, in which the court ruled was supposed to be getting, according to most of the pundits, into the Communications Decency Act, Copyright Act, about whether Section 230 applies or not. The court didn't duck the question. It never reached the question, even though the Ninth Circuit had, because it ruled that they weren't aiding and abetting under the abetting terrorism statute. But the fact pattern, nonetheless, was of a person who had been radicalized to go commit mass murder through speech, through the internet. And I am suggesting that we should be applying a balancing test, as in obscenity and other speech areas, such that we do it in defamation, we do it in other areas of speech, which are all speech. We do it in my own practice area, copyright and trademark involves speech. After all, we restrict them. Courts apply multifactorial tests in doing that. So these are the objections that I've read, not only hearing from people who have posted about it, but other places. I've read lots of articles, and these are the arguments we see against regulating hate speech. I may have missed one or two, but I think I've caught them all. And one of them is an absolutist view of the First Amendment. Anything you say is okay. That's what the First Amendment says. We just saw cases in which the court has expressly rejected that argument. The slippery slope argument that if we start restricting this kind of speech, then we're going to go on a slope to rejecting other kinds of speech, and we're going to be down that road, and the government's going to have control over that, and the government's going to start saying what people can say and what people can't say. Another one is that it drives it underground. At least we know who the crazy people are. At least we know what they're saying. And if they can say it, we can see them. We can do counter speech. We can try and change it. These are the arguments that we see. And of course, I mentioned the chilling effect already. This is from one of the law review articles that I read, which points out that hate speech, like obscenity, impairs the quality of life, because it's not just threats of violence. It changes the tone, and we're seeing that on campus. We're not seeing it only on campus. It changes the entire tone of the discussion. It changes the entire, not of just discussion, of the environment that people are in. And by the way, it's not just what's going on campus. Again, this applies after 9/11. What was the environment for Muslims had that issue. I mean, it's not just that, but right now is hate speech about Israel and Jews. And as you can see, a lot of these have nothing to do with policies, as I said, of Israel. There is an arguable correlation with violent crime, but it's a broader effect. And that's the key. Other countries have just as much protection and respect for free speech as the US does. We have the First Amendment, which creates our own set of jurisprudence, which those jurisdictions in those countries don't have. But as Delgado and Yun pointed out in 1995, lots of other countries restrict hate speech. And one would think that if they were going to have, that if hate speech was going to have a chilling, restricting it was going to have a chilling effect on speech, was going to create people who are afraid to say things because of the governmental restrictions. And by the way, I don't mean just government. I mean, it could be civil law and private plaintiffs. That's a kind of government because the court system goes through is part of the government. Even though it's private parties, it's still a governmental restriction in some respect. And what they say and what they found, and I've done the follow-up, there's no evidence of this, that one would expect that if they were restricting hate speech, it would have an impact on the robustness of debate in those communities. And as they point, no nation has reported any erosion of the atmosphere of free speech or debate. That was in 1995. I've researched it up to today. I haven't found anyone who suggests that in Great Britain or in Canada or in Germany or other places which are industrialized, modern, Western democracies, that such restrictions have resulted in a lessening of robust and vigorous debate. So now we're finally going to get to the actual definition part, which is what this talk was about, but I needed to have these precursors so we have context, that famous word. Here's what the United Nations, how they define hate speech. What is hate speech? It is any kind of communication that attacks or uses pejorative or discriminatory language with reference to a person or a group on the basis of who they are. And this is part of the key as well. And this is where we start diverging from Virginia versus Black and its limitation, at least as written, to threats of violence. Because if it's only incitement, involves incitement to discrimination and hostility as well as violence. And so the United Nations, and I have lots of issues with the United Nations, especially these days, but the United Nations defines hate speech as including incitement to discrimination and hostility, not just to violence. That's one. Here's just one definition I picked out of many. Britannica Online Encyclopedia. It's a speech that denigrates persons on the basis of membership in a social group identified by certain attributes. And they give examples of things that are typical hate speech, including nonverbal depictions and symbols. In the anti-Semitism context and on the alt-right, we see the frog, the famous frog is an example of that. I'm not here to give you every example of hate speech or of symbols that can be out there. There's so many of them in all sorts of communities, but these are examples that you will have heard about. Of course, the swastika counts as one, but there's, again, against all sorts of communities. To me, this is the one we're about to look at is the best definition that I've seen of all of them. And it's a three-factor test. The first is that it's directed against a specified or easily identifiable group or individual based on arbitrary or irrelevant features. Second, it stigmatizes that group by ascribing to it qualities that are widely regarded as undesirable. If you go back and look at some of my earlier papers, I'll always link to a 3-minute video of Yossi Klein Halevi, a well-known centrist Israeli commentator who gave a program. He wrote a book called Letters to My Palestinian Neighbor. He gave a program at DePaul through the JLJS, which I helped put together, and I was there in person when he said it, but he has it on his Facebook page, and he gives a 3-minute definition of anti-Semitism, which is the best definition you'll ever see, with due respect to the others. And he basically says that whatever qualities are loathsome to the community at standards at the time, those are always attributed to the Jews. And so, again, so if it's whatever the quality is, if it's regarded as undesirable. And third, it says that the undesirable presence and legitimate objection of hostility towards that group. I think that's as good a definition as you're ever going to find. It's usable. You can apply it to any given fact pattern. And this is something I mentioned earlier. It doesn't just apply to hate speech against minority groups, right? It can apply to a minority group saying things about a majority group. So if a person of color were to use the C word as to a white person, that definition would still apply because it denigrates the group. If we look at the definition, okay, it's directed against a group. It stigmatizes that group with a quality regarded as undesirable, and it says that that group has an undesirable presence and a legitimate object of hostility. So it doesn't matter which group it's directed at or whether a minority is saying it or not, the definition would apply either way. Examples of hate speech. The N-word, I can't even, it's a word that you can't even say. In one of my papers, and I think in one of my talks, I think it was on the IHRA definition and the dueling definitions of anti-Semitism. I talk about a chief judge in the state of Washington who was giving a presentation on hate speech. And in the context, she was explaining how a word is really an example of hate speech. And she used the word to criticize the word and to criticize its use. But she didn't say the N word. She said the actual word. She lost her chief judgeship. She had to resign from her chief judgeship. Just because she used it. There are those, and I've talked to in some communities who say that if a white person uses the N word, even to quote a rap lyric or a hip hop lyric, that is racism. I'm not saying whether they're right or wrong on that. I'm just pointing out that that is an example of something that some communities will consider to be hate speech. The K word for Jews, the D word for Italian Americans, and the W word for undocumented immigrants, et cetera. Peter.
Would that qualify?
In my view, it very arguably could.
Okay.
In fact, in one of the cases I talk about is NAACP versus Claiborne. I'm not talking about it here because it was in one of my prior talks, in which the white merchants of town brought a claim, and it's used and because the black community had decided to boycott white merchants. And the NAACP's leader in the area had actually referred to people who were Uncle Toms and that they would have their legs broken and made threats of violence against them. The trouble with that case is that the plaintiffs weren't the black people who were intimidated. It was the white merchants. Okay, yeah, sorry.
Excuse me, David?
Yeah, I need to repeat the question. I got it.
Yeah, thank you.
Thank you.
There was just an event at George Washington University where somebody yelled at an African-American congressman, calling him a race traitor and an Uncle Tom. And so that's why I brought that question.
Look, I'm not, like any case, and as good lawyers that I hope we are, by the way, I think you all heard Peter's question that time because he had the microphone. I'm not going to go through every single possible fact pattern because it's a multifactorial analysis and we're going to have to apply it on a case-by-case basis, which is what lawyers do every day in all sorts of contexts. In every case we have, we're applying multifactorial analysis. We're not making prejudgments on whether it is or not. We're litigating the question and having a judge or jury make that decision subject to appellate court review. So yes, that very well may qualify. But I'm not going to prejudge that. In my last talk, I talked about the derision, justifiably, by the way, that the three university presidents, in my opinion anyway, received for their congressional testimony about the use of the word context. But it's also true that context really does apply. It's just that the question they were asked was not a contextual question. It was a softball question that they should have been able to hit out of the park. So, yeah, go ahead. But wait, we need to have the microphone over there. And I don't know if somebody's monitoring the questions that may be coming in on the Zoom call, but go ahead.
In Britain, where they have hate speech restrictions, there have been big, anti-Israel protests. Has there been any lawsuits alleging hate speech there?
I haven't heard anything about the actual judicial proceedings. I know people have been arrested, but they've been arrested here, and then their demand is for amnesty for their arrest. So I don't know what they're doing, and because there's political issues, of course, overlay it. So anyway, these are examples. And other examples are dog whistles and coded speech. In the anti-Semitism context, I've given international bankers and globalists. A lot of the literature talks about, and I'm not sure, at least at certain eras, whether that's true now or not, I don't know, but certainly over time, states' rights was used as coded speech for supporting racial segregation. And some of the literature talks about the use of the word bad hombres as a coded phrase for Hispanics.
We do have a couple of questions in chat, if I may.
Sure.
Two of them actually have to do with the same subject. So it's how is hate speech that threatens Israel, if limited to what should happen to and in Israel, a violation of American law?
Well, hate speech is still hate speech, and it impacts the American Jewish community. These are things that are happening in the United States. They're talking about Jewish identity, the Jewish belief that we have a right to self-determination, and that Israel is our ancient and homeland. And when people say that Israel should not exist, in my opinion, but we're not talking about this. I believe that is hate speech. Now, there can be exceptions. Of course there are. And I talked about it in one of my other talks. For example, if someone is what I call a John Lennonist, imaginist, imagine there's no nations, imagine there's no people, et cetera. If somebody believes that nation states should not exist, then saying that Israel shouldn't exist is not anti-Semitism and it isn't hate speech. But if you only say about Israel, and you don't say that about the United States and France, then to me, that's applying a double standard. That falls within the IHRA definition of anti-Semitism, and it's hate speech. So, I mean, but again, requiring further context about that. But that, so, and it affects the identity and puts threats on the, and creates intimidation, not necessarily for violence, but for everything else, for American Jewish students, for American Jews, for Jews who are afraid to wear their Stars of David walking in Chicago. All right? Not only because of violence, there's lots of videos out there about people on trains who have been accosted verbally. They shouldn't have to put up with that. Nobody should. And that, and by the way, it's true for, again, for other communities, not just the Jewish community. It's just so right now the topic is the Jew, that, and the one that drives me on this, in fairness, is the Jewish community, but it doesn't affect the Jewish community. Running while black, as Ahmaud Arbery did, and was eventually murdered. He shouldn't. The environment was created by speech. Hate speech was created the environment where those people felt that it was okay to do violence. They were radicalized to that by the community that they were listening to and the voices they were hearing and what they grew up with. That was speech that created the environment where they could eventually create the violence, even if there was no speech that actually involved in the actual conduct of grabbing him and murdering him. All right? Nobody should ever have to be afraid because they're running while black. It's absurd. We need to change that. We need to change the environment where hate speech creates people who feel that that's okay to do, or that they have such hatred in their hearts that they can do that, and they learn that through speech. And so we should be able to do something about it when we hear about it and see it. That's my opinion.
We have another question here.
Yes, go ahead.
Can you compare places where First Amendment applies versus other situations, such as in public schools, private companies, and private universities?
All right. So this was covered in my last presentation as well, so we're clear. The First Amendment does not apply to private institutions. It only applies to government. So any private institution, whether it's a private university, a private school, it's not a public institution, does not have First Amendment obligations, or a company for that matter, a corporation does not. Most, and that's also true, by the way, for the social media companies. The social media companies are private institutions who do not have First Amendment obligations, although the court is considering a question right now as to when that starts to blend too close together, whether they are or are not instructed or encouraged by government to take certain actions, and whether that's enough to cross the line. The court hasn't issued that ruling yet, I don't think, but I think it was just argued in this current term. We're waiting for that decision. And the facts, of course, always will decide that question too, right? Did they do enough in that particular fact case? Aside from the legal question of if they did, is that still going to be protected or not? All right. So there's always going to be a question of fact in any case. But most of the private institutions have adopted their own rules and procedures. The universities have speech codes and their own rules and regulations. Certainly Google and the social media companies do. And those are now contractual requirements, right? They could change those contractual requirements if they choose. People might not use them. People might use them. They might change their marketing position if they're not protecting First Amendment rights, or if they're not applying their own codes, but not because the First Amendment requires it. That doesn't mean the First Amendment jurisprudence won't apply, because if they say we hereby adopt the First Amendment standards, they don't say it that way, but if they basically say that, then obviously the jurisprudence on the First Amendment will apply because they've contractually volunteered to do that. So here's other examples of another kind of hate speech. This is again from the British Columbia Office of Human Rights. I just happen to be one that I picked. There's any number of them out there. And these are the kinds of things that we might see that count, that can be factors to be considered as whether something is hate speech. If you look at the next to the last one, by the way, I talked to two of our Hinshaw affinity lawyer groups, the Mediterranean Plus group and the Black lawyers affinity group, and I asked what they consider to be examples of hate speech directed at their communities. And what I got was, among others, where all Arabs are terrorists and radical Muslims, and all blacks are lazy. Another one was all blacks are criminals. Obviously, those are the kinds of things that normalize a perception of a group that are ascribing to them. It's an identifiable group. It's ascribing to them undesirable qualities and justifying hostility towards those group members. Another one that I got back was go back where you came from, which of course we're hearing a lot, interestingly enough, in the anti-Semitic portion of the comments. Now, the poll before World War II, we used to get the community used to get comments, go back to Palestine. And now we're getting go back to Poland or go back to Russia. And in other communities, of course, they get the same thing. So that actually didn't come from a Jewish source, that came from a non-Jewish source. Another community was talking about that. Context matters again. You know, again, it may be almost a joke now, but it's true. Mittal versus Tom. Simon Tam is a terrific person, a terrific speaker. I've heard him speak. He had a band that he wanted to call the Slants. And the US Trademark Office refused it on the grounds that it was denigrating to Asian Americans, and so would not allow the trademark. And he was not taking it for that reason. He wanted to have it to drain it of its derogatory or negative impact by normalizing it as a positive thing. And still the PTO refused to allow it, and the Supreme Court reversed. The Supreme Court said, no, that is not the standard for whether or not he had a First Amendment right to use it. It was not the standard for determining whether a trademark could be met. But again, he was not using it. It wouldn't meet the Parekh test, the one we talked about before, because he wasn't using it to denigrate, and he wasn't using it to suggest hostility. He was using it for the exact opposite purpose. So, but what if a non-Asian group had tried to register that name? We'd have to go through the facts to see why they were doing it and what the intent was and how they would be marketing it. And after all, to get a trademark, you have to use it in commerce. That's one of the requirements for trademark protection, which is what that Mittal was about. So context mattered. But what if a non-Asian group had tried to register the Slants? Would the result have been the same? We don't know, because they arguably would be using it. Arguably, you'd have to determine it as a negative, as a denigration. What if a black group wanted to register the N words, or a variation, or a Jewish group wanted to use the K word? So the context does matter. And you never will hear me say the context doesn't matter. I'm just saying that in that testimony, it was absurd for them to cite context because the question required no context. You know, I've talked about this. Some of these slides are borrowed from my IHRA, my dueling definitions of anti-Semitism presentation. The International Holocaust Remembrance Alliance definition of anti-Semitism was adopted in 2016. It actually goes back in the early 2000s. And it's one paragraph followed by 11 non-exhaustive examples. And this is the definition before the examples: a certain perception of Jews which may be expressed as hatred toward Jews. But this is something that the critics of that definition never, ever mentioned. In fact, I probably read 50 or 60 or 70 articles, maybe more, that say the IHRA definition should not be used, including, by the way, the competing definitions from the Nexus document and from the Jerusalem Declaration. And none of them ever mentioned this paragraph of the IHRA definition. Never. I've seen one article that ever even mentioned its existence. The examples require taking into account the overall context in which the speech or conduct occurred. So context does matter. And as I say, few of them ever mention that. In my opinion, as to anti-Semitism at least, we'd have to have a different definition for racism, but we can use the Parekh three-part test in my view. The working definition would identify when it is or is not anti-Semitic. And in my view, anti-Semitic speech, which meets that definition and also happens to meet the United Nations definition, would be qualified as hate speech. And therefore, if a speech falls within the definition, it's hate speech, and it can therefore have consequences, whatever those consequences might be. It might be suspension or expulsion from school if you engage in it. It might be a civil case if in an appropriate setting, if you can prove damages, intentional infliction of emotional distress, for example. It might be a criminal case if you can prove the requisite intent, which, by the way, in Counterman, the Supreme Court ruled would be recklessness, would be enough. You don't have to prove specific intent under Counterman, at least according to under the statute involved in that case. Whatever those consequences might be, those consequences can flow once it is determined to be hate speech. And in my view, one example of hate speech is if you are anti-Semitic under the definition of the International Holocaust Remembrance Alliance of definition of anti-Semitism. And one of the objections we hear is that, well, we won't know. How's someone supposed to know how to moderate their speech so they don't have those consequences? First of all, the reason we have defamation law, the reason we have obscenity law is to chill those kinds of speech. The reason we have copyright infringement and trademark infringement is to chill those kinds of speech. Trademarks are speech. Copyright is speech. They are words or images or art. There's no debate that those things are speech, and yet we restrict them under the law. And we don't know ahead of time whether a given set of words is going to be infringing on the copyright or not, or whether it's going to infringe on somebody's trademark or not, or whether it's going to be defamatory or not. We have tests to determine that. But it's always an after the fact determination. And it's something we practicing lawyers do every single day. And we've done it for our whole careers. It's been the law, the way law works in the United States, it's forever, since its founding. How fast is too fast for conditions on a driving on a snowy day? In product liability law, how dangerous is unreasonably dangerous? That's the standard. What would a reasonable person do? In copyright law, the standard is substantially similar. I have this question come to me all the time from architects, for example, who've had somebody bring them drawings and say, I'd like to build this house. How much do I have to change it so it's no longer enough? The answer is, I don't know, because we won't know till the jury tells us later. Pat, the microphone is coming around to you.
I certainly agree that we do multi-factor tests every day, but I've been sitting back here trying to think of a fundamental enumerated right for which we do to determine if the right exists. Certainly the current court has moved away from such tests in all regards, but certainly with respect to enumerated fundamental rights like what's in the First Amendment.
Well, okay, so everybody, I think we heard that because he had the microphone. The question is, well, there's the things that I have on the slide right now are not enumerated rights in the Constitution. They're just rights. The right to drive a car. By the way, you have to have a driver's license to drive a car. Okay, that's okay, and maybe fair enough. Okay, and copyright, by the way, is a constitutional right. It's in the Constitution. It's not in the Bill of Rights, but it is a constitutional right to have a copyright. It's set forth in the Constitution.
No, it's an authority of Congress under Article 1, Section 8 that they have the right to create the thing. They don't actually have to create it.
Well,
the word has the word copyright in it, but it's not a right.
I would argue that the First Amendment also doesn't create a right. It creates a restriction on abridgment. Okay, so if we're going to go into that kind of wordsmithing, I would say that the First Amendment doesn't say you have a right to free speech. That's what the courts have glossed it on. What it says is that the government shall not abridge the right to free speech or the right to free assembly and all the other things, and right to religion and all those other things.
What the First Amendment does is restrict what the government can do. What the copyright or what Article 1, Section 8 does is it gives them the right to create something, for the government to affirmatively do something. In other words, the First Amendment is a negative right.
So Pat, you would say that if Congress had never created the Copyright Act, that nobody could copyright anything. There wouldn't be any copyright protection.
Okay. There might be, maybe it would.
There would be common law copyright.
Sure, there'd be common law, but that's something fundamentally different than the statutory.
All right.
Well, wouldn't defamation be an example of abstract determination of a fundamental Bill of Rights? protection?
And obscenity too.
Yeah.
He listed absolute, there are,
That's not on the screen.
well,
Defamation.
applying the standard the court has applied, that we look at the historical right as it was understood at the time of the founding, 1791, when the Bill of Rights comes about. Certainly, defamation was on the menu of things that weren't protected
Okay,
speech.
so there's no question that in the most recent Justice Thomas opinion on the Second Amendment, that's the paradigm that he applied. I have not seen any cases that I have to go, and I've read them all, so maybe I'd have to go back and look. I might have missed one or misunderstood part of it, in which the court has applied a non-balancing test to the First Amendment, for example. So I would say that, first of all, I would criticize, and in Justice, the dissent in the Bruin case, which was the most recent gun case, to me was very powerful. We can disagree on that. I get it. People can have reasonable disagreements on the subject. That's what the court system is there for, is to resolve those disagreements. My point is on the free speech issue that there has never been a case in which the court has adjudicated, and I've looked at every one, that where hate speech is actually protected speech. And I'm saying that it's not under the First Amendment. There are and that there are multifactorial tests that we can apply after the fact, and that the objections to it for such things as chilling speech or that counter speech is the answer. Counter speech is an answer, it's not the answer. In an age of siloed and algorithmic reception and cognitive dissonance, which we didn't know about in 1791, but which every trial lawyer on this call and every trial lawyer in this room knows about. You win cases at trial, and sometimes before trial and with the judge, an opening statement, and sometimes in voir dire, because the jury decides often who they like and who they don't like, and then they ignore the evidence they don't list that came in that was adverse to them. It happens all the time. I've learned over my 45 years of practice that the way to win a trial is to win it at opening statement, and maybe even before that. Now, that's not true every time, right? Every jury is different. Every case is different. But that's a general. We have a doctrine of one of my talks is also about the talk about anchoring, the concept of anchoring and cognitive dissonance. I do an experiment in that talk about that, and we see how it works out for the current audience that's before us at that time. And it doesn't work every time, but it works 80% of the time. I'm always disappointed. Oh well, so much for that. The rest of my talk, it's all gone now. That's what we see, and so we're talking about creating environments which are anti-debate, anti-discussion, and that's what hate speech does. And that's one of the reasons it's a problem. So I believe that we have rebuttable presumptions in law. We have res ipsa loquitur. We have bailment. I've actually tried Fair Labor Standards Act. I've actually tried all three cases involving all three of these. And it's common. We do it all the time. There are all sorts of areas of law which we have a rebuttable presumption. So if somebody meets the test, oh, by the way, there's one more in the Trademark Modernization Act, which I haven't tried on. I haven't come up with a case where I've had to deal with this yet. It only happened in 2020. They created a rebuttable presumption of irreparable harm, and so you can get an injunction, a preliminary injunction in a trademark infringement case. I know I'm getting a little trademark infringy, weedy, but it's the concept is the same. It's not at all unusual in law for us to have rebuttable presumptions that if someone meets the standards to create a cause of action, a prima facie case, that they're presumed to be there, and then it is the burden of the other side, the defendant in that case, to prove it's not. And that's what this next slide is about. The burden is on the speaker, which is not. I am proposing that we apply that standard to hate speech if we agree that there's a proper definition, which is a multifactorial test, which is what we do for speech. We do it for obscenity. We do it for defamation. We do it for other kinds of speech all the time. You know, in defamation cases, there's a question of whether the person is or is not a public figure. That's a question of fact. There's a question about whether there was an innocent construction, which is at least an Illinois defamation doctrine, which is a question for the judge to decide. There's a question about whether it's per se or per quad, which requires different elements of proof. There's a question of whether it's an opinion or whether it's a factual statement. That's going to be a factor that has to be decided by the court on a case-by-case basis, based on who the person is, who the plaintiff is, who the defendant is, what was said, who they said it to, and the context. We do that in speech all the time. And that's my point. These are things that come up every day, all the time. And there's no reason that I can think of. And I've looked at it long and hard. And I'm always subject to listening. And I know Pat and I disagree. I respect his opinions as well, much as I respect any person I know. I just disagree with them, and that's okay. Fair enough. Those are the things that we have to talk about. And I think there's no good reason why hate speech should be treated differently. We have definitions that we can work with, that we can have consequences for, and we ought to have them. Any other questions from the audience? And then we'll go back to the, there. Yeah, go ahead.
Again, thank you. You alluded earlier to other phrasing such as from the river to the sea. How can we apply framework like this where the lines become very blurred between blatant hate speech, which anti-Semitism is hate speech, and the argument that it's innately political, it's anti-Zionist?
Okay, the question of when it draws the line, when does anti-Zionist become anti-Jewish, anti-Semitism? Of course, many Jews, I would say the vast majority of Jews, Zionism is part of their culture just as much. There's plenty that aren't, but I would say, I don't have a percentage. I haven't seen the latest poll or study about what percentage it is, but certainly a lot of Jews, and certainly I would say the vast majority, have Zionism as part of it. After all, I looked up how old the Haggadah is, the Passover Haggadah. Passover is the single most celebrated holiday for secular and religious Jews. People who have never gone to a synagogue will never go to a synagogue. They go to a Passover Seder. What is the last phrase at a Passover? And the Passover Haggadah is 2,000 years old. Next year in Jerusalem. It's part of our culture. I don't mean our religion, I mean our culture. Is that Jerusalem and the Jews are indigenous, and we are the exiles, and that everybody else is the colonialist. Now, you can disagree with that. You can say, and I have said, that we can talk about the arrogance of the European powers at the breakup of the Ottoman Empire in dividing the Middle East into the borders of Israel, Lebanon, Syria, and Iraq. Okay? Because they were arrogant. England and Britain were, but it was the international law, the League of Nations created those mandates. And that's international law, and the United Nations adopted it in 1945, expressly. And so if you don't believe that Israel's borders, that's one of my presentations, and I'm glad to show you the slides or point you to the video. If you don't agree that Israel's borders include, under international law, the entire West Bank, I'm not saying they shouldn't give it up. I'm a two-state solution person personally. That's my political view, okay? But I'm saying you have to start from the right place. In any negotiation, you have to start from the right place. We're talking about anchoring and cognitive dissonance again, right? All of Gaza, all of the West Bank, the Golan Heights is a different issue, okay? Are Israel's borders. And if you don't agree with that, then you also agree that Jordan doesn't have legitimate international borders. You don't believe that Lebanon, Iraq, or Syria does, because they were all created by the same exact League of Nations mandates in the 1920s. And if you and Israel's borders were created by the same exact doctrine. And if you want to read about it in more detail, Eugene Kontorovich and Professor Bell have an article in the University of Arizona Law Review that discusses the doctrine in great detail and how it's been applied in country after country in Africa and every place else after the colonial powers, Britain and France and other countries left, how those countries' borders came to be. And so now I know that's a long, being who I am, that was a long-winded answer to a short question, all right? But the answer is that it's part of our culture and part of our heritage. And to suggest that that Israel shouldn't exist is anti-Semitic. Unless you also are a John Leninist and an Imaginist, then that's different. Then it's not. There's the context. All right, sorry about that. That's who I am. What I
It also seems the word
Phil knows.
Zionist is a new dog whistle, as you
Say again?
alluded to earlier. Zionism is a dog whistle to use that word instead of saying Jew.
And by the way, that's not new. It was the Durban Conference in the 1970s, and the Zionism is racism in the United Nations for that period when that happened. So It's not new, it's just reinserting itself. Any other questions from here, from
We
Zoom?
have several in the Zoom. We actually, you covered a couple of them. But one of the questions is regarding public school teachers and state education codes that govern what they're allowed to say. And this questioner wants to know who or what agency is responsible for prosecution of hate speech. Like, is it the school or is it the courts? I assume is what Roz is trying to get to.
Actually, it's both. If it qualifies as hate speech, I'm just dealing with anti-Semitism now, but it would apply elsewhere. Again, everything I've said applies to all the communities we're talking about, even though I'm focusing on anti-Semitism because that's what's going on right now and that's what I am focused on. But Title VI applies. And Title VI allows two different avenues of activity. One is to make a complaint to the Department of Education, which a lot of people have done. I found that those cases penned for, I haven't handled one personally, but they penned for a long time and nothing ever happens. And what the Department of Education has the right to do then is to reduce or cut off the funding of the school or the school district, if it's a public school, if it's at a high school level, whatever, but certainly at the university level. And I think at the high school level too, and the grammar school level. So that's Title VI, but I think the Title VI also creates a private cause of action, just like Title VII does for employers as well. So there are some cases that are beginning to be prosecuted. None of them have gone all the way through that I know about, involving private causes of action against schools involving Title VI.
We've got another question here, recognizing that all speech is physical in some way in regards to location and form, et cetera. Are there any cases that draw distinctions, especially when groups have done things like taking over sidewalks or common areas or access to buildings?
There's an entire body of law which I have not delved into in the depth that I have with these that discuss the difference between conduct and speech. So for example, some speech, I mentioned it before, and I did look into this a bit, such as burning a flag. The Supreme Court, the US flag, has confirmed is symbolic speech. Burning your draft card is another one. Are symbolic, that's actual conduct, right? You're burning a thing. But that's still speech. It's called symbolic speech. And the courts have adopted that and upheld that as speech. Now, whether a cross burning counts, which actually causes physical damage to somebody else's property, I would say, well, you could argue that it's a symbolic speech, although I would say it's symbolic hate speech, if you're going to call it speech at all. And after all, the cases, Virginia versus Black was a KKK case, Ku Klux Klan case involving, and the court was applying First Amendment speech doctrine to the cross burning and and that's what they were talking about. But I would argue that it's also conduct. So the question of where it crosses the line between speech and conduct is a discussion that I have not delved into as much. But yes, conduct is not protected by the First Amendment. And I would say that blocking traffic is not First Amendment, it's conduct, it's not speech. It might have a speech element, but it's not. And there's a reason, by the way, why the Nazi Party had to petition for a marching permit in Skokie, even though they never marched in Skokie as a result, without getting into too much detail. They had to petition. They didn't just you couldn't just go out on the street and do it. They had to get, because the government, even for speech, has the right for time, place, and manner, or time and place restrictions. There's no doubt about that under First Amendment jurisprudence. But I would say that the example that was given of blocking sidewalks, if you've seen the video of the kid at UCLA who was trying to get through to class, he said, and was not being allowed to because the people were physically putting their bodies in his way, I would say that's not speech anymore, that's conduct, and can be sanctioned without regard to First Amendment jurisprudence or free speech question.
Got one more question. I think then we will have to wrap it up. And this one is one that has come up in the context of the debate in Congress over adopting the IRA definition of anti-Semitism. What is the reaction to the argument from the other side saying that it would make it illegal to say that the Jews killed Jesus?
I'm not sure I can talk about that particular comment. I have to think about that one. But
Okay.
there's no question in my mind that the IHRA definition does not in the least bit restrict speech. And anybody who says it does either hasn't read it or has an agenda. Okay, I've written about this in depth. It's on my blog on Times of Israel, and I talk about it, and I think there should be a video out there about that as well. It specifically says that criticism of Israel is not anti-Semitic, as long as it's the same kind of criticism you would level against any other country, because that's the double standards question. If you apply double standards to Israel and not that you wouldn't apply to any other country, United States, Britain, take your pick, then it's anti-Semitic because you're applying a different standard. And if we looked at the definition of hate speech, again, it's distinguish people from, it's to make a denigrating perspective. And so I would argue that that I believe that the current bill, which is passed the House and will still be I think it passed the House, I certainly passed out of committee, I think it passed the entire House, is perfectly constitutional, that the objections to it are ill-considered, and that it ought to pass the Senate. And I've done an entire program on the dueling definitions of anti-Semitism, and the people who object to it do not have legitimate arguments. And in fact, the competing definitions they propose are in fact just as vague, which is what they claim it is, and just as standardless as they can criticize the IHRA definition for.
Okay, thank you, David, for a wonderful presentation. I want to thank all the people who came to hear the presentation in person and those online. And this is our first hybrid that we've done, and I'm glad that it worked so well. And I also want to let you know that there are other classes coming up, which you can find on our website.